Good morning. Nowadays, I witness multi number of young lawyers are practicing before division bench dealing with the habeas corpus cases. I have already published a book about detention orders. Apart from that, I would like to share this judgment. This judgment is having some two more best points, and also discussed about various aspects of the detention law. Though this judgment deals with the prevention of illicit traffic in narcotic drugs and psychotropic substances act detention order, but the ratios and the subjects discussed in the judgment is applicable to even Act 14 cases. I hope you understand. This is AR 2025 Supreme Court 1685. AR 2025 Supreme Court 1685. Murtuza Hussain Chowdhury versus State of Nagaland and others. In this case, they have, at paragraph 2, the Supreme Court has said, preventive detention is a draconian measure whereby a person who has not been tried and convicted under penal laws can be detained and confined for a determined period so as to curtail that person anticipating in criminal activities. But they say this extreme mechanism is however sanctioned by Article 22 3b of Constitution of India. Significantly, Article 22 provides stringent norms to be adhered to while effecting preventive detention. That's what they say. They have discussed multi-number of judgments and the grounds of detention, all those things. The ratio is most important. Two ratios are here. They say voluminous grounds of detention. So instead of serving a copy, a language known to the detainee, they claim that it was read over to them by orally in the language known to the detainees. They say that is not sufficient. So therefore, if the detainee did not know English or the local language, so it is duty of the detaining authority to serve the copies in the language known to him. That is one thing. Next thing is, very important thing is that the detaining authority who passes an order simply the records placed before him says that I am satisfied and detaining him. That is not sufficient. The Supreme Court has said the cryptic order of detention passed by merely recorded that she was satisfied on careful examination of such proposal and other supporting documents. So that is, they say that is not sufficient in view of section 6. They say state government or central government required to satisfy. That means independent mind should be applied. And the detaining authority must state independent grounds of detention. Crux of the matter. Otherwise, the judgment is not valid. Then another ratio was also they have stated that when multi-number of pages is circulated and explained orally how a detainee can remember all those things and send his effective representation as a facilitator under Article 22. All these things are go through the judgment, read the judgment, take down the relevant points, even if the other side what argued, which were considered, which are not considered, and incorporate in your grounds of detention, writ petition grounds. Number first, what is your primary duty? Primary duty is see that the representation is sent on behalf of the detainee. After going through the grounds of detention, kindly find out what are the lacunas, what all are the practical impediment on the part of the detainee to sending effective representation. All these things apart from all the other grounds. I hope you understand. Best wishes.